toing and froing in the late start and talking sort of in the background while you have been paying close attention to what we're saying, usual technical glitch thing. And our third speaker, we have not been able to get hold of yet, but we are trying. We're looking at an important and urgent discussion on the government's proposal to criminalise hate speech. And we have the honour of some superb speakers on the issue. The proposed remit of the bill is wide and intending, and if someone is found guilty of hate speech, it could have a profound impact both on the individual convicted of the hate speech and a chilling and restrictive effect on society as it tries to navigate what would and wouldn't be considered to be hate speech. Any strengthening of the characterization and the punishment for hate speech is likely to be negatively impact the right to freedom of speech and expression, which is considered the paramount right underpinning any democratic constitutional state. Our guests are Advocate Mark Oppenheimer, Professor Anton Harber, and Cynthia Stimpel. She will join us hopefully in due course. And what we have allowed for is for each speaker to have 20 minutes to present their views, comments, and suggestions. And I will read out the biography just to give you some background before each speaker. Now, our first speaker is going to be Mark Oppenheimer. Mark is an advocate who we've done work with and we know extremely well. And excuse me, the frog in the throat thing. He's a member of the Johannesburg Bar and has appeared in the Supreme Court of Appeal as well as the Constitutional Court in a series of cases that seek to determine the boundary between freedom of expression and genuine hate speech. He ran the widely televised hate speech trial against Julius Malema and the EFF for chanting "Kill the Boer," and that is going further because the judge in the case said it was not hate speech. So it's still open for a final resolution. He's frequently a guest on South African television to discuss human rights and the rule of law. He has authored submissions to Parliament on the bill and to the UN Committee for the Elimination of Racial Discrimination on escalating racial tensions. So, Mark, if I've given you your due, please start the proceedings.
Excellent. Well, thank you very much for having me. I thought what I would start with is a sense of what our Constitution permits and getting a sense of why free speech matters. So Section 16 of our Constitution grants everyone the right to free speech. And it's very broad and generous in the sense that it includes artistic creativity, not just the production of art, but the process itself, academic inquiry, a free press, and access to information. Now, there are 3 cases in the Constitution where your free speech right is excluded. So they're not prohibited by the Constitution. It's just that the right doesn't reach those areas. So the first is propaganda for war. The second is the incitement of imminent violence. And the third, being the hate speech clause, is the advocacy of hatred on one of 4 grounds: race, gender, ethnicity, and religion, and that constitutes an incitement to cause harm. So let me unpack that in some detail. So firstly, if we think about propaganda for war, you're dealing with a cataclysmic harm. The idea that you could have calling on your citizens to engage in a war with another country or propagandizing another war could lead to massive loss of life. And so that gives you a sense of that threshold. The second is the incitement of imminent violence. So violence, in other words, the killing of people, assaulting them, destroying their property, and that it must happen now, imminently. Now, in the hate speech case, we see that there's a watering down. There's no requirement of imminency, and violence is changed down to harm. But the idea is that these 4 particular groups have faced historical claims against them. So if we think about the Holocaust, people were persecuted on the grounds of their religion. If we think about apartheid, people were persecuted on the grounds of their race. And so there's reason to grant these additional thresholds. In South Africa, we've had waves of xenophobic violence, so protecting ethnic groups seems like a wise thing to do. Now, what we've had to actually regulate speech is the Equality Act. Now, the Equality Act doesn't have any criminal sanctions in it. It is a civil remedy. It allows private citizens to go to the Equality Court and lay complaints against other citizens. It also allows the Human Rights Commission to lay complaints. The kinds of penalties that are in place in the Equality Act are financial. So you can be made to pay a fine. You could be made to pay compensation to the person who has complained. And you could be made to make an apology for what you've said. So that legislation has gone through a judicial process. So the initial version of the Act prohibited hurtful speech. I was in a matter cited as Quilani, which is regarded as the kind of locus classicus on hate speech. And in that case, it was found that merely hurtful speech is not hate speech. What the Equality Act does that is different from the Constitution, though, is that it also has the term harmful speech. And so one can be held liable for hate speech if you propagate hatred and the speech itself is harmful. The Constitutional Court in Quilani held that this is constitutionally sound in the arena of the civil setting. And all of the international case law that it utilizes really looks at these sorts of situations where you've got a civil sanction as opposed to a criminal sanction. So no one is jailed. Now, how do you justify any deviation from the Constitution? Well, Section 36 of our Constitution is called the Limitations Clause. And this allows for a right to be limited insofar as it would be reasonable and justifiable in an open and democratic country, and that you can show that there are 5 other factors in place about why you can justify the limitation. So there is some value in the limitation, that what you are trying to achieve will reasonably be achieved through the limitation, and that there are no less restrictive means for limiting the right. One of the ways in which the court limited the right was to include into those categories sexual orientation. John Quilani's article, which was titled Call Me Names But Gay Is Not Okay. In the article, he writes that he prays that politicians will have the balls to change those parts of the Constitution that allow a man to marry a man and ditto a woman. And if we look at the 4 grounds that are listed in the Constitution, no mention is made of sexual orientation. The Supreme Court of Appeal held that sexual orientation is a sufficiently serious ground. It's analogous to the other grounds. It's an immutable characteristic, and that there are levels of homophobic violence in South Africa, and there's enough evidence before the court to allow that additional ground to be added. And the Constitutional Court agreed with that. So that gives you an example of how you could have a reasonable limitation on the right to free speech, and how it could meet the Section 36 muster. The difficulty that we find ourselves in with the hate speech bill is that we now have a criminal penalty. The bill has gone through various different iterations. The first version came out in 2016. I think it came out quite opportunistically in that it was announced very soon after Penny Sparrow's infamous tweet, in which she said that she compared black people to monkeys on the beach, was clearly a racist statement. I think it wouldn't be found as hate speech now. She was originally held liable for hate speech on the grounds that the speech was hurtful speech, and that was the test that was used. And given that hurtful has fallen away, the speech itself would not have been viewed as hate speech. But it was seen as an impetus to produce this legislation to try and regulate racism. And there was a lot of cheering at the time. The feeling was, we need to, be tough on racists and, show them what they deserve and incarcerate them. But the original version of the bill was incredibly draconian. But even in that version of the bill, you only had a penalty of 3 years in jail for a first offense and 5 for a second. This one adds those 2 values and makes it 8 for any offense. So the difficulty with criminalizing speech like that is that, first of all, we've used this all the civil case law to wind up with a hate speech test that doesn't conform with our constitution, we could justify it in the civil setting because the penalties were minor. In other words, making an apology. In most of those cases, all that's required of the person is to make an apology. There is no financial sanction, and it's quite rare for there to be financial sanctions. But even then, it's a deprivation of your property to have to pay 150,000 rand, but it's not the same as being incarcerated for 8 years. And the chilling effect that you have on something like that is gigantic. That it might well be that a lot of speech that would be protected speech, that no one would reasonably think of as hate speech, people might not utter because they are concerned that they will be jailed. And that concern is not just for those who utter, but those who share the speech as well. So what the bill does is criminalize the distribution of hate speech. Now, it might very well be that someone sees something that they find alarming and wants to share it, not with the intention of spreading hatred, but with the intention of shining a spotlight on it, with the exact opposite intention, to say this is a concern, we should be worried about it. But the bill doesn't really look at the mental states of the person who is sharing the speech. It says, could it reasonably be construed that you had such an intention? And so a third party will look at what you did without asking you why you did it, and will then determine whether or not it demonstrates an intention to spread hatred. The other difficulty is that the bill itself doesn't define hatred. So, and it has a definition of harm that's also incredibly broad. It includes the term social harm. Now, our case law doesn't really deal very much with what social harm could mean. It seems like an elastic term that if you are undermining the social values of South Africa, that you could then be incarcerated. We have seen those terms used in other jurisdictions. So in Malaysia, for example, they criminalize social harm. And someone who was jailed was someone who had an OnlyFans account, and she posted sort of sexually explicit photos of herself. This was felt to undermine the social harmony of Malaysia, and she was then incarcerated. So what counts as social harm seems to be a very flexible value. The other difficulty is that if we look just at the civil hate speech cases that have come out in recent years, it's quite hard to draw a golden thread between them. There appears to be quite a fair amount of arbitrariness in who is held liable for hate speech. And it seems to depend largely not on the content of the speech, but rather on who the speaker is and who the victims are. And so, for example, Julius Malema ran a case against Kenny Kuneni for referring to him as an individual, as a cockroach and a frog, and it was held that this amounts to hate speech. Now, traditionally, the distinction between hate speech and things like criminality are that hate speech targets groups. It doesn't target individuals, whereas criminality is an insult at a particular person. And so here, what you have is no mention of a group, clearly political rhetoric that's aimed at a particular person. Kuneni's testimony was that when he used the term cockroach, it was because when he grew up, he lived in quite a poor neighborhood, and he would have cockroaches infesting his food, and they were an irritant to him, and he would sweep them away. And that's how I viewed Julius Malema. And so here you have a situation where Kuneni is held liable for hate speech. That matter is on appeal. But you could imagine that the magistrate who will be enforcing the hate speech bill could very well incarcerate people for long terms of time for insulting language directed at individuals. That kind of case will be used as a precedent. The recent judgment from the Supreme Court of Appeal finds that certain displays of the old South African flag will amount to hate speech. And there's a concern, of course, that other symbols besides the old South African flag could very well be determined to be hate speech, and that someone couldn't know that in advance. So there is currently litigation in relation to the Springbok symbol. The Springbok symbol was the symbol used by the South African rugby team during apartheid. That team was a racially exclusive team. Black people were barred from playing for the team. It was a symbol that reigned during apartheid, and the argument has been made that it is directly analogous to the old South African flag, and on that basis ought to be banned. So you can imagine a situation where someone shows the Springbok symbol, and that a complaint is laid against them, and that they are incarcerated for it on the grounds that is analogous to other apartheid symbols. So it's quite hard to know what one could be held liable for. And there is that danger then when you don't know that the prudent thing to do is then to not say anything at all. And the difficulty when we silence speech is that we lose this opportunity to engage in the marketplace of ideas. That one of the important things for allowing free speech is that we can find out what's actually true, that we can debate each other in a way where we're not worried about being thrown into a prison, that some people will say things that are incredibly unpopular and will be held to be unpopular for a very long time and will eventually reach a state where everyone accepts them. So, for example, it was the case that for most of human history, people thought that slavery was morally permissible. It took abolitionists over 100 years to fight against slavery, to express in words why it was immoral and repugnant. You had similar battles about interracial marriage. The idea to say in South Africa that a white man should be allowed to marry a black woman would have been seen as repugnant, and now is rather commonplace. Similar views with regards to gay marriage. Many people have found the notion incomprehensible or offensive, and now the views have shifted. So sometimes the unpopular, offensive view, because of the marketplace ideas, is able to persuade the other side. And so we cannot be so confident that we always know what is right, given how fallible human history has been, how many mistakes we've made. And that's why you want to allow some broad remit people to express their ideas. The other concern with living in a society where you don't know what's happening because people aren't expressing themselves in speech is that you miss out on opportunities to see who the real threats are. So one of the things that's useful about certain kinds of hate mongers is that they tell you about their hatred, and you can keep an eye on them before they go and perform an act of physical violence. So it gives them the steam valve where they can express their views. You can counter dialogue their views. You can point out to them why they're wrong. You can do that in the public arena. And you get a sense of who might very well be a threat to national security, and you can keep an eye on them. If you don't have that information, you drive those views underground, and you could suddenly have an eruption of actual violence as opposed to the mere sprouting of words. I do think there are cases when we should be genuinely concerned about speech. So the Rights Assemblies Act says that if people call on others to commit a crime, that you can treat them as if they've committed the crime themselves. And John Stuart Mill, the famous liberal philosopher, gives a case where he thinks that you can restrict speech. So he says, imagine that you're standing in front of a group of factory workers, and they are in front of a factory, and they're holding pitchforks and lanterns. And you say to them that the factory owner is exploiting you, and you should rise up against him, and you should burn down the factory. And given that moment, given how liable it is for that tinderbox to erupt, that the factory owner could be burnt alive in his factory, he thinks there's good reason to prohibit that speech. In some senses, it's an instruction to commit murder. What Mill says is that you could say that thing under different circumstances. So if you wrote that in a newspaper, you don't have the angry mob in front of you, that people are dispersed, that is much less likely that you will have any actual eruption of violence, and that there is room for there to be counter dialogue. But it does seem like there are cases when it would be legitimate to have a penalty for some kinds of speech. But I think the difficulty we have with the bill is that the ambit is so broad that so much speech that we think is important to have in this marketplace of ideas will disappear, that it'll be used as a weapon against people. It'll be wielded by the powerful against the powerless. It'll be sold as a way of combating racism, but actually what it'll do is that it'll empower those who hold racist views to punish those that they dislike. I think Anton will probably speak about this in more detail, but one of the difficulties I think that we'll find is that journalists who want to be able to expose politicians for various things that they've done will suddenly find themselves targeted by hate speech litigation. We know that Karen Morn is currently being prosecuted by President Zuma, and this legislation will provide more room for the criminalisation of speech by journalists. And I would imagine that journalists who are in the stock and trade of reporting on events that happen, of exposing atrocities that occur, sometimes expressing themselves in ways that are vitriolic, may very well find themselves in situations where they face prosecution. I think the other thing to realize as well is that all of our case law on this goes through an equality court, where you have a judicial officer who is trained to deal with this sort of litigation. Because this is a criminal statute, it'll be dealt with by ordinary magistrates' courts. And so not many people know this, but to be a magistrate, you don't require a full law degree. So you could be in a situation where someone has a gut feel about it and doesn't like you or doesn't like what you said, and that a judge would find it merely offensive and protect the speech, but the magistrate finds differently, and now you find yourself lingering in a jail cell. Some people are able to defend themselves and have, enormous financial backing so that they could take their matters on appeal, but not all South African citizens can do that. Litigation is incredibly expensive. It's very time-consuming. It can take many, many years for a matter to be finalized. For example, John Quilani's article was written in 2008. Judgment was finally handed down in 2021. So you can see how long it can take and the toll that could take on you, especially when you have the sword of Damocles hanging over your head of 8 years of incarceration. So it strikes me that the bill is dangerous, that there's still an opportunity to comment, that in prior rounds of comments, those comments have made an enormous difference in removing some of the more despicable elements of the bill. And so I would say this is an opportunity for citizens to express themselves, to show their concerns, and to read the proposed bill and submit why they think it might be inappropriate.
Thank you, Mark. Thanks very much. Certainly made note of questions I would like to ask when the time comes. She's not on screen, but we have tracked down Cynthia Stimpel. Cynthia, thanks for joining us, and apologies for the technical glitches, as is inevitable. I'd like to now introduce as our next speaker, Anton Harber. Anton is the Caxton Professor of Journalism Adjunct at the University of Witwatersrand. He's also the co-founder editor. He was the founder editor of the Weekly Mail, now the Mail and Guardian, editor-in-chief of ENCA, and chief executive of Kagiso Broadcasting. He's a board member of the Global Investigative Journalism Network and a former chair of the South African Conference of Editors and the National Association of Broadcasters. He has served on the boards of the Freedom of Expression Institute, the Institute of the Advancement of Journalism, Kagiso Media, East Coast Radio, Jacaranda, Radio Jacaranda, and more. He's the convener of judges for the Taco Capo Award for Investigative Journalist, which and has served as a judge on the Sanlam Financial Journalism Awards, the Vodacom South African Journalism Awards, and the CNN Multi-Choice African Journalism Awards. Anton has written 2 books, Dipsloot and The Gorilla in the Room. So if anyone is well placed to discuss certainly the media issues that are raised by this legislation, it has to be Anton. Anton, welcome and thank you.
Thank you very much. That was a long, an unnecessary long introduction, I must say. But thank you very much for the opportunity to talk about this bill. I think we all have concerns about it, and it's very good to be sharing and examining them closely. You know, just this week, I had a journalist turned down a generous grant to investigate the construction mafia in this country. Young journalist who's done good work before, applied to a fund I run, the Henning Normalo Fund for Investigative Journalism, for money to assist her in doing what is clearly could be an important and valuable investigation. She turned it down, having got the grant, because of safety concerns. And I raised this because it really drove home to me the notion of a chilling effect. Wasn't that she had particular threats? It wasn't that particular threats had come from the so-called construction mafia. It was in the wake of what has happened recently to whistleblowers and liquidators in the Murray shooting, and of course the Deo Karan killing, that have had a chilling effect on journalists and others who are looking to investigate, expose, and tackle these things happening in our society. And it really drove home for me how we have learned over time that censorship comes in many forms. It's not just the state restricting what one can say or write or publish or do, but it can come in many different ways from many different sources. And one of them is to threaten serious consequences to someone who pushes the boundaries of what is socially acceptable, or not even what's socially acceptable, but just does something like expose wrongdoing in the society. And I think it's worth remembering that under apartheid, a lot of apartheid censorship, not all of it, but a lot of apartheid censorship worked that way. It was the threat of serious consequences that had a chilling effect on journalists, for example. So there were areas where there was direct censorship. You couldn't publish a book unless it had been cleared. But in news, generally, censorship was exercised by threatening consequences like closure, banning, imprisonment, fines, if you broke the censorship law. And that had, we learned, a really chilling effect, because a lot of the media had to be extremely cautious as a result, and therefore practiced a kind of enforced self-censorship. And I think it's worth remembering that that is what the laws that threaten things like imprisonment for things one says can have on individuals and on society. I think I want to start by stating our views on hate speech as the Campaign for Free Expression. Hate speech is abhorrent, and we support measures to prevent and stop it and deal with those who do it. But I'm talking here about real hate speech, not speech that is offensive or critical or irritating or pushes the boundaries, but speech that really threatens imminent harm to groups in particular. And our concern since this exception for hate speech first appeared in our Constitution in the 1990s was that the Constitution gave it a tight definition, and we always had a fear that there would be a pushback on that decision, an expansion of that decision through legislation or jurisprudence or court rulings, or the development of the law in one way or another, that would gradually expand free speech to the point where it has the potential to be used in future against speech that is merely offensive, irritating, or critical. So I think we have to remind ourselves that our concern is not just how a growing intolerance is pursued by the current governing party, but by how it can be used in future by those who are less tolerant, more authoritarian, and use loose definitions to lash out at those who fall short of hate speech and who are just maybe making offensive speech. I think it's worth saying that we also have no problem with the first part of the bill that deals with hate crimes, and which essentially adds extra penalties for crimes motivated by hate. We don't have a problem with that. We're concerned about the impact on free speech by the limitations on by its treatment of hate speech. And I do want to say this. Mark referred to the legislation that was first published, the draft legislation that was first published a few years ago as this bill. And that really was an appallingly constructed, badly written, and very clearly potentially unconstitutional bill. But many of those organizations that have concerns have been lobbying consistently for a number of years for changes to prevent that law being enacted, for it to be improved at least. And the new bill is considerably improved. Some of the worst features have been taken out. And I raise this because it's important to say that the lobbying does have an effect. The representations, at least some of them, were heard. Not altogether. We still have problems with the bill, but it is considerably improved. And I think it's important to understand that the process does at least allow for lobbying to have that kind of impact. But the worst of the overly wide definitions, the lack of a need for criminal intent in committing hate speech crimes, the inadequate exceptions for journalists and artists, all of these things have been somewhat improved in the latest version. We remain with the core issue, which Mark has dealt with, and which I think it's important to emphasize, which is, why do we need this bill at all? We've got the Equality Act, we've got crime and injuria, we've got laws against incitement and against assault, and we've got the first part of this, which will mean that if you commit any of those based on hate, then you would be susceptible to getting a harsher sentence. So we have in our law and in plenty of ways to deal with hate speech, and we've shown that they can be used to convict the worst culprits of unrehabilitated hate criminals. And I think it's an important question to ask, why then are we getting this law? Because I think it points to the potential problem that we want to highlight. I believe the concern is with those that have not got caught up in what law existed before this. And there are two cases in my mind that I think infuriated the governing party, and where they would like to have seen action, and they actually explicitly said, at least some within the ruling party said they would like to see action against these cases, that I think highlight the potential danger in this bill. And I cite the case of Zapiro, the cartoonist, for his Lady Justice cartoons, which infuriated the Zuma administration and which led to many threats to him and his work, including him being sued by Zuma, and interestingly, that he initiated a legal action against Zapiro, but never actually pursued it. And the other case that comes to mind is Brett Murray's drawings at the Goodman Gallery of the Spear of Zuma, which infuriated a cross-section of the governing party, who led protests, including threats of violence. And I think that part of the motivation was a sense that characters like that fell outside of existing law, and what was required was a law that may draw in people like them. And I think that's extremely concerning, because if we're looking at any law that's looking at locking up journalists or artists, fundamentally, we know that is wrong. We know that in this day and age, it is only in the most extreme cases that you could possibly consider locking up journalists or artists, if at all. And I think it's worth bearing that in mind. I also want to highlight why we reject imprisonment as the appropriate punishment for hate speech, because I'm saying that I accept a legal action against extreme forms and dangerous forms of hate speech, narrowly defined. But introducing the threat of an 8-year imprisonment, I've talked about the chilling effect that will have on many journalists and all kinds of work. But it's also important to say, I think that the international norm that's been accepted very widely is that imprisonment in cases of speech should only be considered in the most serious cases of irredeemable purveyors of hate and dangerous purveyors of hate. And that's not what this law does. This law introduces an 8-year penalty for breach of the law, and that worries me enormously. I'm very conscious that our experience also is that imprisonment creates martyrs. I think we have seen around the world that it's a way of dealing with those who, for example, promote the swastika or Nazism or Holocaust denial. Very quickly can turn them into martyrs for the neo-Nazi movement, for example. And you know, when you think of some of the things our politicians say, or some of our politicians say, that are hate speech or border on hate speech, one does want to say, do you want to be locking up these people, journalists, artists, politicians, in ways that can turn them very quickly into martyrs for causes we are trying to stop? I would also pick up on Mark's point that we cannot challenge views when they are forced underground. The pursuit of truth, I say as a journalist, but for all of us, it depends on open debate, enabling us to scrutinize alternative political arguments and deliberate on our social values. The threat of imprisonment, of criminalisation, can have exactly the opposite effect. And we learned this under apartheid. We all, or many of us, set out to find and read banned documents, to find what Mandela was saying and thinking, precisely because they were banned, he was jailed, it was driven underground. It raised interest in those things much more than it prevented, particularly young people with an interest in those things, from hunting them down and wanting them. But it prevented public exposure and debate and examination of those ideas and facts and the things that lay behind them. We have a general concern of definition creep. That slowly, the tight definition of hate speech in the Constitution is pushed out. Every stage seems to widen the definition of hate speech and take in more elements around it, add new categories for it, remove some of the qualifications. Now, the Concord has knocked back some of those attempts, I'm pleased to say. But I think we need to be eternally vigilant about gradual creep, that each little bit seems insignificant, but can cumulatively become much more significant, particularly in the long run, when there are those who deliberately want to use such acts, such definitions, to go after journalists and artists and their political critics and opponents in the future. I think I want to end, let me talk a little about the exceptions to the law. So there are exceptions for bona fide journalism, for artists, academics, a qualified allowance for them. Now, the journalists one is an interesting one because it says that it's written in such a way that I think that as long as a journalist, him or herself, does not promote hate speech, they can report on it. And in a way that matches with our code of conduct, because our obligation when we report hate speech is not to not report it, to not say that so-and-so said something that may or may not be hate speech. And the public need to know that. But to make sure we do it in such a way that we are not promoting hate speech, that we're contextualizing it in a way that people can see that this may be dangerous and harmful and may in fact be hate speech. Artists and cultural workers, for example, don't have such codes. And their work is often to push the boundaries of offensiveness. among some artists to get one thinking about these difficult and tough issues and confronting them head on. And I worry that the qualification may not be enough to protect the likes of Zapiro and Murray. I would like to see, for example, a very explicit exception for parody and satire, because while they may fall under the definition of artists, I think we need to make it clear that if it's bona fide, clear satire and parody, and in that context, we live with it. As Mark said, the context in which something is said or published or broadcast is absolutely critical, because one thing is dangerous in a live political context, which in print, in a different context, really is less or much less or not dangerous at all. And we do have to take that into our thinking. I want to end, though, by saying that I think that as people who are concerned to keep this an open society in which everyone feels free and there's no chilling effect against provocative opinions, everyone's free to speak out and express themselves and pursue their political views, providing there isn't the threat of imminent harm, that we need to get a much wider acceptance of the complexities and the values of free speech, free expression generally in our society. We need to take it beyond the media, which is the focus for much of the talk about free expression. And we need to work hard to ensure that South African citizens broadly get the value and the complexities of free expression. And we grow in this country, as we've seen grow in some countries, a massive popular and passionate support for the notion that we must be free to express ourselves. Thank you.
Anton, thank you very much. I have when you mentioned parody and satire, I thought as soon as you interfere with the ability to express humor, the society's in trouble. Cynthia, thank you very much for joining us. Sorry about all the technical shenanigans at the beginning. It's very good to see you. I'd like to just give your biography and then leave it to you to say what you need. Cynthia is the executive director of the Whistleblower House and has been since February 2022, supporting whistleblowers to retrieve their dignity. In 2019, she started a support group for whistleblowers in South Africa and is campaigning for the rights and plights of whistleblowers through her company, Citizens of Conscience Foundation. She's also a motivational speaker, speaking on her story as a whistleblower and making a difference where you are. She is the author of Hijackers on Board, published in 2021, on the South African Airways saga. And just to, I suppose, keep her sane, she is a yoga instructor for adults and children. She's a certified director of IODSA and currently a board member on 4 boards: Amnesty International South Africa, Johannesburg Children's Home, Health E-News, and the BCCSA. She volunteers at Accountability Now, Radio Veritas, and does community work. She was awarded in December 22 by Blueprint for Free Speech Special Recognition Award for Integrity and Moral Courage. She was also the recipient of the Risk Influencer of the Year by the Institute of Risk Management, South Africa. In 2019, she received the Citation of Integrity Award from the Airline Pilots Association of South Africa for having stood up for the truth in the SAA transaction. Cynthia had a long career in banking and for the last 10 years was at SAA in her capacity as the financial risk manager, and for the last 2 years as group treasurer. Her highest qualification is an MBA and her dissertation topic, Business Continuity Strategy. Cynthia, welcome. Anton has already alluded to the issues that affect people who speak out and the chilling effect it has on them. The floor is yours.
Thank you very much. Good morning to everyone and to the organizers of FW de Klerk Foundation, my fellow panelists, and all those attending. My talk today is basically on the free speech for whistleblowers who expose corrupt activities and need to hold government and private sector to account. So why is it imperative for whistleblowers to have free speech? In the quote of Edmund Burke, he states, "The only thing necessary for evil to triumph in the world is that good men and women do nothing." And that is exactly what we've seen, is when no one says anything and no one does anything. My question to you is rhetorical. Our country and the world as we see it right now is in a quagmire of corruption, with many human rights violations and unethical behavior. We're experiencing the worst leaders in countries across the globe, and we are reading and hearing of wars in Sudan, Mali, Ukraine, Syria. And so where does this bring us then for free speech relating to whistleblowers? I would like to draw an analogy to a soccer match. So when you're watching a soccer match as an audience or as a referee in the different roles or as the actual soccer player, when that referee blows that whistle, we all listen. Whether you are the player, you listen, and whether you are the audience, the attendees watching the match, you listen. And obviously, if there are second or third referees, they all have to listen. The reason for that is they're highlighting that an error has happened or an offside or something that is against the rules of the soccer game. But when a whistleblower speaks out, they are gagged. It's as if someone is putting their hand over their mouth. They cannot speak. They're not allowed to speak. And if they have spoken, their words are twisted and changed and pushed against them. And therefore, it is imperative that whistleblowers should be allowed to speak and have free speech. For whistleblowers to speak up and stand up for the truth, or for any atrocities they've witnessed or observed, any fraud, they are the ones who suffer consequences. If one looks at in an international space, we've had Edward Snowden of NSA and CIA, Julian Assange of WikiLeaks. In the local field, we've had many in our own country. And if I can just recall recent news, Motsebeni, the MP, Member of Parliament, Motsebeni Tswana, recently found to have been guilty of losing public trust. He was involved in Optima Mine and the Tegeta exploration. However, the staff in Eskom and Trillion who spoke out at the time because of these deals, Marcelo Motepo, Bianca Goodson, Suzanne Daniels, they've all suffered losses in their jobs, losses in society, to their reputation, to their career. And what's the repercussions then for the MP? He gets 1 full term suspension, parliamentary term suspension, and that's it. No further loss to him. So that brings me to how important then is it that whistleblowers are protected? Research has been done by many organizations, and recently the Ethics Governance think tank and the University of Nottingham have engaged in a project with South Africa, which was funded by the UK government, and they did some interviews with many whistleblowers. And they came up with very significant views about the whistleblowers. and the majority saying that the current legislation for whistleblowers, which is the Protected Disclosures Act, is not worth the paper it is written on. They said it is purely theoretical and does not protect whistleblowers holistically in any way. So while this view is held particularly as a bitter end for everyone, whistleblowers associated with state capture have suffered more. For them, the institutions that exist to investigate unlawfulness and to protect private citizens are used as tools to intimidate and to silence them. Because those they were accusing had the power and the resources and the deep pockets of the state at their disposal, which they used against the whistleblowers. Another case in point, recent case, is Prasa case, Goya, who's won every case. She's won her disciplinary hearing, she's won her labor court case. And yet Prasa board is still out there and still retaliating against her and victimizing her. And that is what whistleblowers suffer. Pure retaliation, victimization, assassinations, as mentioned earlier by Anton Harber. How many have we seen? Babita Deokaran was a senior financial officer at the Gauteng Provincial Department. She was an important witness in the investigation with the Special Investigative Unit into corruption, and which was involving fraud amounting to over, at the time, 300 million. And already.
Probably the beauties of load shedding, if that's not unlikely, we'll blame them anyway. Perhaps while we wait for Cynthia's line to come back on again, I'd perhaps just pick up from a point she made and ask you, Anton, that we've got an incredibly compromised government, and there is rot at all levels, and criminal activity at all levels. When Cynthia talks about, protecting people, they continue to be victimized by state-owned enterprises, etc. I would have thought, given that we kind of can't really rely too much on the authorities, that the only thing that can perhaps have an impact against those perpetrating this sort of behavior on whistleblowers is media exposure, and a lot of it.
I think you make a very good point, and it's been very clearly demonstrated how critical an open, free, independent media is in these difficult times. There's no question that, as you say, we have a compromised government in many ways. We're coming up to an election which for the first time looks like it'll be contested. And that's always a difficult time for free speech and open debate and free media. But certainly what the Zuma period showed us above all was while the ruling party does have a worrying capacity to compromise the independence of many of our institutions of accountability, the justice system, the public protector, we had only two institutions that really showed they were able to maintain an important level of independence in that difficult time. The one was the judiciary, and particularly the Constitutional Court, and the other was the independent media, the private media. Now, I think we've already seeing emerging issues with our judiciary via what's been going on to the Judicial Services Commission. I think the jury's out on that, so to speak, but we're seeing that that's a worrying area. We can be left with a situation where the only institution, because it's privately owned, has an independence that's less vulnerable to state interference, is the media. Fortunately, we have some media owners, we have some editors and journalists who are fierce about that independence because of what we've learned over the many years of apartheid, how important that is. So I have no doubt you're pointing to something very important. The media is an absolutely critical institution in protecting, enhancing, not just our democracy, but our economy as well.
Mm.
I think that's a point often underplayed. And that we are fortunate in that it remains quite vigorous in some ways, quite independent, and has by and large been protected by the Constitutional Court.
Mark, let me go to two related questions from members of the audience. Nicola de Jager said that while recognizing the local motivations for the bill, how has the introduction of the bill been influenced by an international context of increasing political control of thought or speech? And Sebastian Shatov says, the Constitution mandates courts to apply international law. If the bill is challenged on the grounds that it oversteps international norms alone, will it or not be sufficient to strike it down?
Yes, let me deal with Sebastian's question first. So what our Constitution does is says that when you are considering legislation, you must interpret it in accordance with international law. It's not that international law is going to trump our statutes. What we use to determine whether a statute is lawful or not is our Constitution. But the international law is a guide. And it has been a very useful guide specifically in this area. So if we go back to the first big hate speech case, the first big hate speech case is Islamic Unity in 2000. But one of the first cases heard by the Constitutional Court is the matter of Case, which is a free speech case, authored by Yvonne Mahoro, who I was very troubled to learn recently was in a horrible car accident and is still in hospital. But really what she did was go and scour the foreign sources of law to try and find out what are the international norms. And that case really has played an enormous role in our thinking about free speech and how important it is. And so traditionally, the Constitutional Court has drawn on foreign sources of law and international law. So, for example, the Rabat Plan of Action is cited quite explicitly in the Kolani case. It talks about the various factors you should take into account when determining whether something is hate speech. So, for example, how big is the audience? Who is the person speaking? Do they have an enormous amount of power, or they are nobody? Is there an imminent threat that violence could erupt? What is the exact content of their words? So that test is drawn from international law and has definitely played a role in interpreting our statutes. But I don't think we could be in a situation where an international norm could trump our local statute. It might be that it's used to understand what the statute is, and that our Constitution is ultimately used to find that this particular legislation is unconstitutional for being overly broad. With regard to the first question, I think we are in an interesting climate at the moment where there are a lot of threats to free speech. It's become an environment people feel much more uncomfortable speaking out. We have, in some senses, imported some of the American culture war stuff into what we do in South Africa. What's difficult about that is that our context really is quite different from America. That the demographics look very different, that the economic disparities look very different, that the norms look very different. So there is that danger. America prides itself on a very strong right to free speech. Their First Amendment means that you cannot restrict speech as the state. You can pass no law that would infringe the right of a free press. They don't have hate speech laws there. But what they do have is a very strong culture at the moment against free speech, that the kinds of social sanctions that are used to suppress speech are enormous. So you find people being fired, specifically at universities. They are often shamed into resignation. that the pressure brought to bear for unpopular views is enormous. I think that's happening in workplaces as well, enforced by HR departments. There's this difficulty with working out what role social appropriation ought to play in a society. On the one hand, you might say, well, a reason why you don't need to criminalize is that citizens are quite good at pointing out why they dislike speech, and they can apply pressure accordingly. On the other hand, Mill warns about this tyranny of the majority, that it's not just about a right to free speech, it's a culture of free speech. That, and Anton talks about this very beautifully, that we need to have norms where we accept people are going to say things that we don't like, and that's okay. One way to deal with things that you don't like is to disagree with them. When we talk about a culture of tolerance, we don't tolerate things that we approve of. We don't tolerate rainbows and butterflies and blue skies. We tolerate things that upset us in some kind of way. But we think that the cost of tolerance is worth it. Because sometimes you tolerate an idea that you dislike, and maybe you change your mind, or you get information from that actor saying intolerant things that can then help you work out how much of a serious issue is this. So, for example, in South Africa, we don't ban Holocaust denial, and we don't ban displays of the swastika. Now, my grandparents escaped Nazi Germany. I think it's an absolutely abhorrent thing to do, to wave a swastika around or to deny the Holocaust. I think it's the kind of thing that can cause serious emotional distress. But it almost never happens in South Africa, and people are free to do it. So that gives me very useful information, which is that when it does happen, you can target it, you can see it, and this has happened quite successfully. So, for example, Nsebo Dlamini had described himself as a friend of Hitler. He was SRC president at WITS at the time. The Jewish Border Deputies, instead of saying, let's imprison this person, said, let's have a conversation with him. Let's bring him to the Holocaust and Genocide Center and show him the implications of what he said. And he publicly renounced what he had said. And that's very, very powerful. Often having someone who is a prior hate monger renounce their views is even better than someone who, believes the view from the start. A good example of this is someone like Megan Roper Phelps, who was part of the infamous most hated family in America. So the Westboro Baptist Church would hold up signs saying God hates fags, and they would picket dead American soldiers' funerals on the grounds that they deserved to die because America was tolerant of gay people. And, she was an active member of this organization. Her job was to spread hate on Twitter. But through a process of conversation, she was ultimately reasoned out of that view and now plays an incredibly powerful role fighting against hatred. So there are other mechanisms to deal with this kind of thing, and often free speech is the best way to deal with it and a more effective way of dealing with it than heavy-handed sanctions of throwing people in prison.
That I agree with you that it's quite disarming and powerful if, for example, you get that hater into a room and serve him a cup of tea, because he's not in a position of power. He's sitting on an equal or lesser position than his victims, and it's long lasting. Imprisonment surely largely will only raise resentment of both of people facing imprisonment and the people who watching people be imprisoned for speech of this nature. I wanted to, sorry, there was something I just wanted to come back to on that, but I'll leave it for the moment. Let me just have a look at some of the questions I wanted to raise. Now, it's against Mark, something you raised, and that is the and I think Anton raised it as well, and that is the question is, the motivation of hate speech being the basis of a crime. Now, surely, if someone has committed a crime of any kind, it doesn't matter what sort of crime it is a crime, and they're being found guilty of a crime. And then the issue of whether it was motivated by hate speech and the effect it had on it is a matter for determining a sentence under putting forward aggravating circumstances. I just don't understand why what is really behind why the government is so determined to make that a distinct and separate issue. Not to mention, obviously, crimen injuria and the Equality Act. But what do you think is behind this? Is it a sense that a government is vulnerable for the first time? The ruling party is vulnerable. Is it a sense of, you've actually got a government that is not by nature democratic? It has a much more sort of authoritarian streak that it would actually like to show after decades of very free speech. I mean, South Africans took to free speech after apartheid like ducks to water. And is it really a reflection of panic, perhaps? Or is I'm not being cynical enough?
I'll give a view and then I'll hand over to Anton. So the first part of your question really is about the hate crimes section of the bill. The hate crimes section will take into account whether you're motivated by hatred against a group in your penalty. In some senses, what this does is codify what our common law does. So to my mind, there's a difference between vandalizing someone's house as an ordinary crime and vandalizing their house, to say, die Zimbabweans, or, you deserve to be burnt alive. That's motivated by a kind of ethnic hatred. And I think that should be taken into account when you have a penalty. That's a separate question from the speech questions. Now, I'd alluded earlier to the fact that this first version of the bill came out in 2016, and it comes out after the Penny Sparrow statement. Something that I didn't say, but I think is well worth taking into account and was acknowledged at the time by Thuli Madonsela, is that if you go back 2 months, 2015, what you have is President Zuma firing one of our finance ministers, the Rand tanking, thousands of citizens taking to the street and saying Zuma must fall. And you have this crisis in the governing party where you've got a mass movement against you. And so what do you do when you are reviled and hated? You find someone else who the public can hate instead. And so Penny Sparrow, who is basically a nobody from like the middle of nowhere, really, it's like Northern Natal, she's a retired estate agent, suddenly becomes enemy number one. And this enormous amount of effort is put to say, this is the real problem in South Africa. Forget about Jacob Zuma. This person is the person we must deal with. And, it's not enough that we can only make them pay a fine and apologize. We need criminal sanctions to stamp out racism. So John Jeffries, the Deputy Minister of Justice, sees this as this incredible opportunity to put through this entirely totalitarian legislation. It's worth reading the original version of that bill to see how despicable it is, how it would have been used to silence many journalists, many individuals, would have amassed this huge amount of power for the state. And they took this wonderful opportunity. And of course, the diversionary tactic of not talking about Jacob Zuma, brilliant. And at various junctures, it was thought that this bill would die because civil society has been very good about pushing back against it. DRSA, for example, has been this wonderful platform where people can express their views on legislation and sign on to write their own submissions. Not merely a petition, you write your own submission. If you look at this particular bill, it says that 78,000 people participated in that process for the 2016 one. So there was this pushback, and as I say, the bill has some of its really hard edges have been sanded off, but it is still dangerous. And as you point out, the governing party, especially when its back is against the wall, would like to accrue to itself as much power as possible and be able to silence its critics as well as possible. And even the threat of 8 years in jail will be enough to ensure that many people don't say critical things about you, lest they linger in a prison cell.
Perhaps I can pick up on that, Sarah, because I agree with Mark that I think the motivation lies in the fact that we have a government that's facing a number of deep and difficult crises and problems and challenges. And this is an easy one to deal with. An easy target, and you score some political points by saying, look, we're dealing with racism, even when I don't think you really are dealing with racism. And that's my point about whether we need this law at all. So I think the motivation is to say, this is easy and we can score some political points from it. I think it's important to keep in mind the perspective that, governments facing various challenges, always try and act against their critics and use their power in the state to act against the critics. So interestingly, and the ANC's faced always some quite sharp media criticism. We saw the threat of the security bill and a huge civil society and media reaction to that. It was passed by Parliament, but never signed into a law. So interestingly, there was a push to limit the media and its investigative journalism, stopped really by civil society, making it politically expensive for the president to sign it. There was a threat. You recall the ANC adopted the policy that there needed to be a statutory media council and ombudsman and a structure that would break down the self-regulatory system and put in place a state system. It never even got drafted into law because there was such furious reaction to it. It was kept there as policy, as a threat, but never seen through. So we've seen attempts, and I'm only citing two of the best known, to limit criticism, to limit scrutiny, to limit accountability, pushed back each time either by civil society or, one should say, the Constitutional Court. So this is an ongoing fight that takes place in every democratic country, and it's something we live with. Governments under threat will try and limit their critics and use the law and their machinery to do so. The court, civil society has to push that back at every opportunity. It's an ongoing fight.
One of the comments I just wanted to make is that if you think about it, the Sparrow, Mombo, Katsavello cases were all, but for the existence of social media, it couldn't be latched onto with the vehemence that it was. And so, as you say, I mean, you have these essentially nobodies. I hope that's not too hard. And a ruling party who could take it on, and I mean, they pushed poor old Penny Sparrow through the system within 9 months. I mean, I haven't seen anything go through the legal system that quickly, probably ever. But can I just ask, isn't it really a case of that it is for the elites? It's for the powerful, whether they be political, whether they be rich. The ordinary person, and I call myself the ordinary person, there is no way, if I wanted to take this up, I could afford either the time, the emotion, or the money to challenge these issues or challenge an issue of alleged hate speech. Mark, do you want to go and if Anton wants to follow on?
Yes, so there's an interesting dynamic that we have with the way that the equality legislation works, is that a private organization can go and lay a claim, and we've seen civil society organizations do that, who have strong backing. So, for example, the Jewish Board of Deputies acting through the Human Rights Commission against Bongani Masuku. Now, in the criminal setting, what you'd have is an individual laying a complaint to the state, and then the state taking over. So you do have that situation where the prosecuting authority now will decide. Of course, there might very well be an enormous amount of arbitrariness in terms of who is prosecuted and who isn't. What we've seen largely, that the people who are most vehemently sought after by the Human Rights Commission have been private individuals without much power, without much influence. That the politicians who have been, let's say, sued in these cases have generally evaded being held liable. So I mentioned earlier this Rabat plan of action, which is adopted by the Kolani court, which basically says that the position of the speaker really matters. So in other words, if you're a powerful politician who leads, let's say, the third biggest party in South Africa, and you're standing on a stage in front of thousands of people, there's meant to be heightened scrutiny. But instead what we find is that there's much lower levels of scrutiny against those people, and heightened levels of scrutiny against the nobodies like Katzavelos or Momberg. What's difficult about Momberg's case is that she strikes me as an intensely dislikable person who basically made every possible effort to bungle her litigation. She was offered pro bono assistance, I think, by multiple lawyers. She, struck me as someone who's probably quite mentally ill, who in that moment seems to be having a manic episode. But what you have ultimately is that she's the first person who's held liable for criminal injuria and sentenced to jail. So before, what you had was, in the 80s, you had people who were held liable for criminal injuria for using the K word, but they weren't jailed for it. But because Momberg is so unlikable and because the public sentiment is so strongly against her, the feeling is, well, let's stick her away. No one's going to miss her. What then happens quite soon afterwards is that precedent is used against someone else in a situation that is much more ambiguous. I think there's a single mother who was accused of using the term, who denied it. She said that what I'd said to the person was, "You have a fat bum, please move out the way," and was then incarcerated. And the judge said, "I'm bound by the Momberg case." So, you have this creep that happens. And I think often some people are incapable of seeing that we live in a common law system where you are setting precedents that will have future effects. And so you have someone who everybody now goes, they're despicable and we don't like this thing and we should come down on it like a ton of bricks. But they don't think that there will be consequences to doing that. So, for example, in the flag case, AfriForum's line in that matter was, we don't particularly like the old South African flag. If you bring it to an AfriForum rally, we're going to tell you to put it away. We find it offensive and unhelpful. But we think banning it could have severe ramifications for free speech. That if your principle for banning symbols is that they offend people, well, there will be other symbols that will be targeted. And ultimately what you have is a banning of that symbol. The Supreme Court of Appeal has narrowed the original banning, so it doesn't cover all displays. There are some exceptions in place, but there is now a principle that said that some symbols can be targeted. And immediately what we had in both cases were further calls for other symbols to be banned. So after the Equality Court came up with their judgment, the FF said, well, if we accept that the old South African flag is an apartheid flag, let me tell you about another apartheid flag. It's their Israeli flag. We should ban that flag. After the Supreme Court handed down their judgment, they said, well, now that we've banned the old South African flag, we should start tearing down monuments, which are symbols of apartheid. So whenever you're fighting for speech that is offensive, you're doing it on uncomfortable territory. But there is a reason to draw some kind of line in the sand, which is that there's going to be something that someone finds sacred that they once protected. During the NCOP discussion meetings about this particular bill, some people started saying, well, languages like Zulu and Xhosa use a lot of idiomatic expressions that are quite colorful and might be misinterpreted to amount to hate speech. Is this going to be covered? And of course it'll be covered by it. They hadn't thought that that would be an effect. Some of them said, well, there's these sacred struggle songs that we quite like. We like to keep singing them. And the answer from the representative from the ministry was to say, well, as long as it's legal, it'll be fine. Which means if we think it's not legal, then you're going to jail. So, there's going to be something that someone thinks is important to them that they should be allowed to say, and they will be jailed for it because of this legislation. That's worth bearing in mind.
To add to that, Anton, before we come in, and welcome back, Cynthia, and obviously it pertains to the flag case. What for me is really additionally problematic about the old flag case is, first of all, that it's almost never seen anymore. It has really receded into the background. It's isolated at best. So you really, in a way, mostly are going to have to go looking for it to find it. So it gives it an importance that it was losing. That's the one thing. And the other thing is, if you're talking about symbols that, that cause offense or hatred, and sorry, this is going to sound really like, but what about, well, whites do that to me. I lived through apartheid. I have terrible experiences of it. Am I being a bit over the top on that one? Perhaps let me ask Anton and then come back to Mark and Cynthia.
Yeah, I think you're being a bit over the top. I mean, it's one thing to say a flag can symbolize, a flag or a swastika can symbolize something that really can cause me psychological anguish. if you're saying I've got a problem with whites because of apartheid, you've got a problem, and that you can't deal with whites in the way you do with flags. One is a flag. So I'm not sure why I could draw a line from one to the other. But the important thing about the flag, I think, to bear in mind is it's all about context. It's all about, in certain cases, it's clearly used to try and incite hurt, harm, and etc. Sitting in a museum or in a book about the old South Africa, or used in a different context, even publicly, and you would shrug it off. Now, I'm not sure how we get that differentiation. I mean, we would need Mark to tell us, because there you require our courts to say, well, this is, here are some rules for when it's acceptable and not acceptable, so that it's not arbitrary. But I think we are concerned with, as Mark has pointed out, that you can't find constancy in the implementation of the law. And so it's looking a little bit more arbitrary than one is comfortable with.
Sorry, Mark, do you want to add to that?
Yes. So what the Supreme Court has done is say that if the flag is displayed in the course of bona fide artistic expression, reporting, or an academic study, then it's protected. And while the original decision would have prohibited a private display of the flag, the new one doesn't. It also adds in a further protection, which is that a non-gratuitous display is protected. So it's only the gratuitous displays plus the exceptions. So that does sort of seem to narrow it down. What it does do, of course, is push the can down the road to work out, well, what's going to count as gratuitous and what's not. I always think that when I was a child, whenever the Mnet magazine would arrive, first thing I would do is have a look through what movies were available that month. And they all had an age restriction, and they had a rating for language, sex, and violence. And they also had a box for whether that language, sex, and violence was gratuitous or not. It turns out that every single movie that was ever shown by Mnet, that violence or sex or language was non-gratuitous. The box was there just to say, don't worry, we don't show you gratuitous content in all cases. So that strikes me that if gratuitous means done without good reason, that there will always be some good reason that could be shown. Some of the interesting cases in which the old South African flag was displayed, one was by a group of black protesters who wanted to show that the ANC government were acting just as badly as the National Party, and showed the old South African flag to demonstrate that. Ayanda Mabula, who has produced a series of paintings lashing out at Jacob Zuma, used the old South African flag quite often in his work. What worries me, of course, is that when you can be jailed and when a magistrate decide whether your art counts as bona fide or not, I get worried. That someone might say, well, I don't like this work of art. I actually find it very offensive, so it's not bona fide art, and I'm jailing you. That's the worry. But yeah, we are in a situation where the can has been kicked down the road on the flag. I gave a lecture at WITS about it, and I asked all of the students. This was just after judgment had been handed down. I said, how many of you have seen the old South African flag in the last month? Everybody's hand goes up. They'd all seen it everywhere in the press, on news media, everywhere. Now they're all in their 20s. And I said, before this, let's say 5 years ago, how many had you seen it? No hands go up. It is an incredibly rare thing to have seen. And what we've done is grant this thing an enormous amount of power and change its meaning, so that those that now want to use it as a free speech symbol will do exactly that. Or you'll find some simulacra of it. So I was in New York recently. The New York City flag, which is derived from a Dutch flag, looks very, very similar to the old South African flag. So you will have people using those colors. There was an outrage about one of our famous runners wearing shoes in those colors. And Fikile Mbalula wanted to stop her from wearing those shoes. The runner was Caster Semenya. So it's unclear that you'll ever kind of solve that kind of problem.
Cynthia, do you want to add to that? Sorry, you muted.
Yeah, with the old flag, it does bring back negative memories and connotations. And I would rather that we evolve, and as we've seen, our new flag has always has embraced unity, has embraced togetherness and identity for South Africa, because too many times we see ourselves as diverse in culture, religion, race, and skin color. But it's the flag that unifies us. So for me, I would rather that we focus on a vision of South Africa, a unified South Africa, and look at what do we all find common ground. What's brought us together was when we won the Rugby World Cup in 1995. That flag was all over everyone's cars and homes. And again, in the 2010, when we won the soccer, we've seen the flag really flown with pride, and to be associated, people wrapping themselves in the flag, having it on their cars. And I just feel we need to get out of this, stop looking back and being a Lot and become like Lot's wife and become a pillar of salt, rather but looking forward, and how can we then embrace the good that we have as a country and start unifying ourselves as a nation. Thank you.
Cynthia, I'd just like to comment on that, and then put the last question of the morning to you. You deserve some time. But the comment is exactly to support that, is notwithstanding what we may be thinking in our heads or feeling in our hearts, if we're at a cricket match or we're at a rugby match or a soccer match and the flags come out, that's what comes out, the new flag. Let's call it the new flag 30 years later. And you know, there's not a lot. I think that's the sort of plea for unity generally by the government is a problem, because we're not always going to be unified about things. Unity is a fairly rare thing to actually achieve. And the fact that we're not unified is what actually spurs the debate and perhaps the tolerance, as Mark said. I think two things do unify South Africans: a sporting event and load shedding. And if you want to see unity, that's the time to see it. Cynthia, the question I wanted to ask you is, you mentioned earlier about the sort of slap on the wrist that Mosebenzi Zwane got for his role in state capture and the Likhor mine. Might not one of the problems be that we have been so overwhelmed by the level of corruption in the state and the extraordinary investigative journalism that has brought it to us? But we do have the detail. That's perhaps it's a plus and a minus. But aren't we at risk of becoming sort of overwhelmed and tired and not protecting the whistleblowers, or not standing up for them, or not protecting hate speech in general?
Yes, currently, I think firstly, we were lulled into false, I speak for 94 as South Africans, we were lulled into a false way that here we are together, we will grow, there's hope for South Africa. And it was. I think those initial years was indeed economic growth, there was excitement, there was euphoria in the country. Then when the Zuma administration came in, we all, I feel in my sense, my personal life, my family, we focused on just doing your work and the best in your community. And so you expected government to hold themselves accountable. You expected government to do the right thing. And I think that was every citizen's expectations. And so when some people were aware of fraud. There were some stories coming out in the media, and I, for one, assumed government would take care of stuff. You know, in my own work field, obviously, I was quite a strict person in my own work ethic and with my team. And so when I started seeing stuff happening in my division was when I spoke out. And I noticed, so did other people when I spoke to them, that it was just not tolerable anymore if it's your area. But if it was another area, well, I wasn't aware of other areas. I was more aware of South African Airways issues of corruption only through the Zondo Commission. And I feel like I was wearing blinkers. I was working in the company and I just focused on my division, you know. And so, and I think it's probably the same for us. So now we face, there is an overwhelming amount of evidence of the fraud and corruption. And I believe, though, that we all now have the opportunity to do something about it in our small way. We cannot allow the country to continue its way, the way it has. We cannot continue that our voting system is the same. We cannot continue that our government continues doing what it's done to each of its citizens when they've been voted in to do certain things. It's clear in the Constitution. It's clear in many of our legislation what's supposed to happen, but government has not been held accountable. And we're all waiting for someone to hold them accountable. You know what I'm saying? And so who is that person? And my own mantra is it starts with me to make a difference. I have to do it. So if I can hold my councillor in my area accountable, then I must do it. I can't, you know, it's too far for me to reach out to the president or to others. But if I start holding my area accountable, what's happening in my community accountable, what's happening in my church accountable, and we all do that, it will filter. It will be like the ripple effect that we all start holding various people accountable, because that is exactly why they all got away with it. And the case in point now is Parliament gives a light sentence to someone who, if they have to go and calculate the cost, and I think here, Anton, you guys with the extreme investigative journalist type background can quantify the cost of those decisions that Parliament makes to this country. And it's over, my calculation is over 3 trillion has been lost through corruption. And so, we need to start with that. I believe it is overwhelming. I totally agree with you. And if I sit in conversations, if everyone's not complaining about load shedding, it's about government, but no one's coming up with solutions. And I think we as South Africans have been able to come up with solutions. Just look what's happened with load shedding. Everyone has found a way to circumvent the load shedding some way. There's people already fixing the potholes, you know, there's people resolving certain issues in our community, and everything in our country is broken right now. Our health system is broken. Our education system is broken. Our whole infrastructure is broken. But if we sit back and look at someone else, we're not going to fix it. So here I feel it's up to each one of us with whatever little talent we have or skills. You combine it and it exacerbates when it's my skill with another person, and we can achieve it. So I believe we've got that resilience. So many, like Imtiaz Suleiman, has spoken about the resilience of South Africa across the board. We've seen it many times, and it's just now for us to look to ourselves and how can we start fixing things. And we mustn't see our diversity is actually a wonderful thing. We need that diversity. It makes us rich as a country. And when we look at that diversity, how can we collaborate and work together rather than pushing one another aside? And the fact that we all have difference of opinions on certain issues is good, because you need to debate, you need to argue. You cannot all be thinking the same, because then we become nothing. And so for me, it's just, here's an opportunity for us now to stand up and be counted and to do something about whatever else issue we passionate about. Thanks.
Cynthia, thanks. Perhaps a just comment you raised, Imtiaz Suleiman. There was an interview on the NCA, and at some point somebody said, the interviewer said, well, you know, people have said you should be the president of the country. He almost got it right. He said, not a chance. Those people don't know how to do anything. So we unfortunately can have to disregard Mr. Suleiman as a future president, unless those working for him learn how to do things properly. We've gone a little bit over our time, and so it leaves me to thank you very much for participating in what I think has been an extraordinarily informative event, and it's on an issue that is not easy to get your head around when you just being confronted with it for the first time. And legislation can look very overwhelming and arcane, and I think it's terribly important, both because of the potential rights we may lose and because we need to understand the context in which legislation like this is being drafted. So Cynthia, Mark, and Anton, thank you very much for being with us today on this great occasion.
Thank you.
Thank you very much.